The first part of this course is going to be a comparison between law and religion. Of course, there are many aspects related to each, and the comparison could focus on a lot of these different aspects. However, we are going to focus on the following aspect: rules. This comparison is going to be between religious rules and legal rules, therefore focusing on the notion of rules itself. In a later stage, we can proceed to a comparison between systems. And in a legal sense, systems are a group of rules bound together by a certain purpose or certain activity. The specific outcomes of this first part are the following: to familiarize you with the concept of rules, to initiate you to the application of syllogism. Those who are good in mathematics may already know what syllogism is, but syllogism is very important in law and it makes it resemble mathematics. Of course, it will give rather a false image of law, because law is not just pure logic. And ultimately, a judge will never give his decision based on only logic. Other factors must be accounted for, such as the results, while formal logic do not care about results. It's a process. So law cannot be compared to logic in the sense that the process is what guides us to the result. And the judge will never judge only based on the process. He will always take into consideration the result. However, syllogism as a method is used by legal thinkers and legal practitioners on a daily basis. Third outcome is actually comparing between legal and religious rules, knowing what do they have in common and what distinguishes them from each other. And along the process, we will identify the major sources. Along this first part of the course, we are going to identify the major sources of law, and therefore to introduce you to law in general. You can see on the screen the outline of part 1, and I remind you that part 1 is a comparison between legal rules and religious rules, while part 2 will be a comparison between religious systems and non-religious systems. I mean religious legal systems and non-religious legal systems. So this part 1 is divided into 2 chapters: the actual comparison between legal and religious rules, and then a comparison between the sources of these legal and religious rules. And we will finish with a synthesis. You can also see a focus on chapter 1. In chapter 1, we are going to first see the common characteristics and then the differences between legal and religious rules. Let's begin with section 1 of the first chapter, the common characteristics between legal and religious rules. This video will only deal with a certain part of the chapter, of the section, and we will leave the other points to the next week. The two main common characteristics we will be discussing are the general and hypothetical structure of the rule, whether it's religious or legal. And in the second step, we are going to see syllogism, as I already said, as a way to apply these rules, which is also a common method between law and religion. However, before we start with explaining these common characteristics, we have to explain certain, and we have to agree on the terminology we are using. So we will have to define what a rule is, then what normative discourse is, and what deduction and induction mean. What is a rule? I invite you to research the meaning of rule in any online dictionary you can find or any dictionary you have. You will find many meanings. Read them all. Okay, because in this slide, I just chose the meanings that we will use in this lesson. However, I invite you to read all the meanings of the word rule. So the meaning we are going to abide by is the following: a prescribed guide for conduct or action, a regulating principle. You must note that in French sometimes we use the two words règle and norm as synonyms. But in English, a norm will mainly lead to non-binding rules or non-precise rules, more as principles, but let's say higher principles. So they are not exactly the same in the English language. However, among the many definitions of norm, we can find this one: a principle of right action binding upon the members of a group and serving to guide, control, or regulate proper and acceptable behavior, which makes it quite close to the meaning of a rule. However, a norm is usually, as a word usually given to higher principle or to broader principle than a rule. A rule will be more specific. However, the word or the expression normative discourse is used to identify or to the word normal or the expression of normative discourse is usually compared or opposed to descriptive discourse. A normative discourse is a discourse that tells us what to do, whereas a descriptive discourse is a discourse that describes something. So you can say of a descriptive sentence that it is wrong or true, while you can't say the same about a normative sentence because it is just an order. Do the test that you can see on the slide. Read both sentences and tell which is normative and which is descriptive. So when we speak about law and rules, we are mostly speaking about normative discourse, not descriptive. Rules are there to tell us what to do. We can't discuss if they are true or false. They are not a description of something that is already existing. If we take a look at the classic scientific method, the method that has become the criteria to tell whether a certain intellectual enterprise is scientific or no. It starts with observation and therefore description and ends with induction of a law. For instance, if I want to know, if my research is to know what kind of relation exists between watering a plant and the growth of this plant, I will start by putting a hypothesis. I will say water is good or water helps plants to grow. And then I will start by observing. I will observe the behavior of plants when they are watered and their behavior when they are not watered. Their behavior if they are watered regularly or not regularly. I will do all kinds of experiences and I will observe and observe and observe. And then based on my observations, meaning based on the description of what I see, I will be able to induce a general rule. I will say, yes, my hypothesis was true. Water is good for trees or for plants. Water helps plants to grow faster or to grow, etc. Whereas in law, we usually start with the norm, with the rule. I don't need to do any observation to induce a rule. The rule is already given to me by the legislator. So in general, legal thinking does not follow the whole classical scientific method, since it starts with the rule. It starts with the rule which is already given by the legislator. Mentioning the classic scientific method and comparing it to legal thinking brings us to discuss deduction and induction. Both are logical methods. In law, deduction is used much more than induction. So what is deduction and what is induction? Deduction is applying a general rule on a particular case. I have the rule saying that whoever steals will go to jail. I catch someone stealing. I bring him to justice. The judge, upon investigation, condemns him. You have committed theft. Therefore, the judge will apply the rule. You committed a theft, you will go to jail. Another example. You do remember 2 or 3 years ago, during the corona pandemic, we had to put our masks in public places. So if I'm going to a concert, I will have to decide whether going to a concert is a public place or not. A concert is a public place, and therefore I will have to put my mask by application of the general rule to the particular case. However, induction is the other way around, in a certain way, because it means inducing a general rule from the observation of particular cases. While in deduction we are going from the general to the particular, in induction we are going from the particular to the general. Newton, for instance, the man who discovered the theory of gravity, he observed many cases of fruits falling off trees, of objects falling on the ground instead of falling or going up. And upon these observations, he was able to infer a general rule, which is gravity. Now, if I want to, and this is usually what happens in the scientific method, after you induce a rule, you have to test it to see whether it's correct or no. Suppose Newton, by induction, first he observed fruits falling off the trees. He induced a rule, which is gravity. He needed also to test this rule. Then he can use deduction again, because Newton will say the general rule is if I leave this pen or if I leave this feather, it shall go down. Then let us apply it to a particular case. I will drop this feather, I will drop this pen, they will fall down. By deduction, he was able to prove the law or the rule he was able to infer early on by induction. So this is a scientific cycle, and as I said, in law usually rules are given to us by the legislator, so it is not necessary to start by induction. No, the first common characteristics between a religious rule and a legal rule, meaning these characteristics that are general to every rule, are the following. They are general and they are hypothetical. So the first common characteristic is generality. A rule must be general. Whether a religious or legal rule should be general, meaning it designates one or more person based on their abstract situation. It does not designate them individually, particularly. So this group of persons could be a group of one or many. The number of people implied or involved in the application of a rule does not mean the rule is not general. And generality of the rule is evaluated regardless of the number of people it is applied on. I will give an example. The rule that says the President of the Republic shall take an oath on the Constitution once he's elected. This is a rule that applies on only one person at a time. There can be more than one president at one time. So the target of this rule is only one person. However, this rule does not designate the president by his own name. It designates him by his office, by his position. So it is a general rule, even though it is applied on only one person at a time. Now, a rule can apply to everyone. For instance, the criminal code, when it punishes theft or murder, it could apply to a category of people. For instance, labor laws that apply to workers, military laws that apply to military or certain specific accidents or instances. Catholic Church commandments, to take a religious example, apply only to Catholics. Again, rules related to the Pope are religious rules that involve only one person, yet they designate him by his position as the Pope and not by his individual person. And while we're discussing the generality of the rule, we must distinguish between a rule and a decision. A decision is the application of a rule on a certain case. For instance, parking violation is punishable by fines. This is a general rule. If a certain person is parking where he should not, then he will be punished by a fine. And that's a concrete decision aiming at a particular person. So rules never designate someone by person, a particular person, while decisions do designate a particular person. And you judge a person. So the decision involves a certain individual, while a rule is more abstract, is more general, since it designates situations rather than particular individuals. The other common characteristic between legal and religious rules, actually it is a characteristic of any rule at all, is the hypothetical structure. Any rule you can think of, whether religious or legal or grammar or ethical, etc., is composed of these two elements, a hypothesis and a consequence or an order, a commandment. So if the hypothesis is realized, we will have to apply the consequence or the commandment, the order. You can take the three following examples. A religious example. You shall attend Mass on Sundays. The hypothesis here is the day being a Sunday. What should be the consequence or the commandment or the order? Attend Mass. If you sin, you should confess. The hypothesis here is to sin. So if I effectively do sin, I will have to go to confess my sins. And grammar as well. A complete sentence must include a noun and a verb. So the hypothesis here is to write a complete sentence. If I'm asked to write a complete sentence, then I should include a noun and a verb. A legal example. Anyone who commits homicide will be punishable by hard labor. The hypothesis here is committing homicide. If you commit homicide, then the consequence would be to go to jail and hard labor. Think of any rule you have in mind. You will be able to identify a hypothesis and a consequence or a commandment. And in case the hypothesis is realized, then there will be this consequence, or you will have to abide by this command or this order.